Hi, everybody. Thanks for tuning in. My name is David Goldstein. I'm chair of the nonprofit tax-exempt religious organization practice group at the Certilman Balin Law Firm. And thank you to Serini and Associates. We are doing a Serini short today that's going to cover fiduciary duties of board members and officers. Fiduciary duties of directors and officers in a nonprofit. There are a couple of fundamental precepts. First, directors and officers of nonprofits have legal duties that we refer to as fiduciary duties, and that's pretty well understood. What's a little counterintuitive and surprising is that there can be personal liability to directors and officers for breaching these legal duties. There are three fundamental legal duties under New York law, and I should mention that we're talking about New York law here, and other states are analogous and have similar duties, but there are some differences between states. So we're going to talk about New York law, and the other little technicality I should mention is that, of course, this is for informational and educational purposes. It is not legal advice, and legal advice requires an attorney-client relationship. So back to substance and education. The three fundamental legal duties under New York law of a nonprofit director are the duty of care, the duty of loyalty, and the duty of obedience. And we're going to sail through those pretty quickly. First, the duty of care, which is actually set forth in the not-for-profit corporation law, section 717A. A director or officer must discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. This is basically the oversight function. It requires familiarity with the organization's finances and activities and regular participation in its governance. This slide gives you an outline of some content that describes the duty of care in a little bit more detail. There's some really helpful New York State Attorney General Charities Bureau publications that are available on the Charities Bureau website, or you can contact me and I'd be happy to send you copies. One is right from the start, talks about responsibilities of directors of not-for-profit corporations. There's a couple of legal cases here mentioned, the Dowling College bankruptcy, where the board members and the CFO were sued personally by the bankruptcy trustee for breach of fiduciary duty, some internal controls and financial accountability, and the policies and procedures are critical in terms of the oversight function of board members. And then there's the critical role of audit oversight, and there's an Attorney General guidance document on that. Second primary legal duty is the duty of loyalty, and that requires that a director must act in the interest of the organization, requires an undivided allegiance to the organization's mission when using the power of his or her position or information concerning the organization or its property. And one of the main areas that we see the duty of loyalty play out is in conflicts of interest and related party transactions, which are very heavily regulated in New York and very important to the Internal Revenue Service as well. The least understood of the three primary fiduciary duties is the duty of obedience, and it's less well understood and less well known because the other two primary legal duties exist in the for-profit world, but the duty of obedience is strictly a not-for-profit law concept. What does it mean? It means that you've got a duty to ensure that the organization complies with applicable laws and regulations and its internal governance documents and policies. That's a lot. If we stop for a minute and think about the breadth of a duty that requires every single board member and every single officer to ensure that the organization complies with applicable laws and regulations and internal governance documents and policies, that's a lot, particularly when we realize that there are multiple layers of laws and regulations, federal, state, local. So the duty of obedience requires compliance with laws and regulations. And of course, in New York in particular, the focus is the not-for-profit corporation law, but there are many other New York laws that need to be understood and complied with. And of course, there are additional layers of laws and regulations, federal, state, and local. The not-for-profit corporation law is not a best efforts under difficult circumstances standard. It is a law. It has mandatory requirements and procedures, bright lines. It's rigid, inflexible, and unforgiving. And this is something that comes up a lot. Lots of new clients walk into our doors with some sort of legal or governance issue, and they had relied on the fact that they were doing the best they could. They were volunteers and were working really hard at the mission and also at compliance. And that is not at all the standard under the law. It's a law. It's not best efforts. It's hard and fast. rigid requirements that have to be understood and complied with. The duty of obedience also requires compliance with internal governance documents and policies, particularly the Certificate of Incorporation and bylaws. Certificate of Incorporation contains your corporate purposes, and you're limited to activities and use of assets only in line with those corporate purposes, and the bylaws are the internal rules for the governance of the organization. So I thank you very much for tuning in and hope to see you again. And I hope that this presentation on the fundamental legal duties of nonprofit directors and officers under New York law was helpful to you.